Rumiantova. I use she, her pronouns, and I'm the associate coordinator here at the National Coalition for Civil Right to Counsel. We're again just really excited about the turnout for this event. Folks are continuing to come into the room. We are already recording. I just want to make sure that everyone is aware of that. Just a little bit about the NCCRC for those of you who are unfamiliar with the with the organization. We're a project of the Public Justice Center, which is based in Baltimore, Maryland, and we work to advance and support the work of advocates on the ground, advancing the right to counsel in critical civil cases. We're the only network around the country that really focuses on those key civil cases where housing is at stake, health, benefits, safety, and we advocate for and help to advance the right to counsel in those cases. So our network started out in 2003, and 20 years later, we are 600 plus participants and partners strong, and our membership is around across 45 states in the US. I welcome you all to head to civilrighttocounsel.org after this webinar to check it out, to look at all of the work that we're doing, especially around the right to counsel for tenants facing eviction, which is what we are focused on today, for beyond the courtroom and the tenant right to counsel's impact more broadly. So for today, what we're going to start out with is just a brief right to counsel for tenants overview from John, our coordinator, and then we're going to head right into a panel discussion. Our panelists are already spotlit, and I'll introduce them in just 1 minute. I want to point out that we're going to be closing this session at about 2:50 Eastern, at 11:50 a.m. Pacific. And the reason for that is that we run a monthly right to counsel implementation working group call, and that's going to start at 3 p.m. Eastern. And so we're trying to give folks just a little bit of time for those of us who are heading into that meeting after this webinar, to give just a little bit of time for that. I do want to say, before I introduce the panel for today, that in terms of asking questions, we thought about, saving some time at the end for a question and answer period, but we think with this large meeting format and the amount of folks that are already joining us and are on camera and ready and willing to engage in this conversation, you're welcome to raise your hand during the presentation. If you want to ask a question, you're welcome to pop your questions into the chat, and we'll keep an eye on those and try to integrate them into the presentation today. So in terms of our panel, we're moderated today by John Pollock. Many of you are familiar with him. He's the coordinator of the National Coalition for Civil Right to Counsel, and he'll be facilitating the conversation that's taking place. In terms of our fantastic speakers, we're so grateful to Pablo Estupiñan, who is currently the campaign director at Strategic Actions for a Just Economy, SAGE, and that's based in LA, and the campaign director of the LA Right to Counsel campaign there. And he was previously the interim coordinator at the Right to Counsel New York City Coalition. I know many of you probably know from all of our kind of promotional materials about the right to counsel and tenant for tenants facing eviction that New York City was the first city to pass that right in 2017. And that was due to a lot of that really powerful organizing work that Pablo was a part of for many, many years in New York. And now he is in LA and joining us today, and we're grateful. We're also joined by Thomas Freeman, and Thomas is a staff attorney at Greater Hartford Legal Aid, and that's in Connecticut. Again, you might be familiar with the right to counsel ordinances and laws that now exist in 22 jurisdictions. Connecticut passed the right to counsel in 2021, and Thomas works in the housing unit at GHLA and does a lot of the work within that right to counsel program at GHLA. And so we're really excited to hear from Thomas as well. And finally, we have Ora Prachovnik, who is the Director of Litigation and Policy at the Eviction Defense Collaborative. You might be familiar with the EDC out of San Francisco. San Francisco was one of the first cities to pass the right to counsel, and they did it by ballot initiative. A really powerful right to counsel program exists in San Francisco now, today. And we're just really excited that Ora could join us today and participate in this discussion. All right. We noticed when folks registered that some of you are super familiar with the right to counsel for tenants, and some of you might be coming from a space that doesn't really or hasn't really explored the right to counsel for tenants, but are interested in this conversation. I'm going to hand it to John to do just a brief introduction to the right to counsel for tenants. And we're going to go through a couple of slides. That'll be about 7 to 10 minutes. And then we're going to enter the conversation that we have planned for you all today. So John, take it away.
Thank you so much, Maria. And we're, again, thrilled to do this today. And I think this is a subject that we've often gotten asked about to sort of dive into what right to counsel's benefits are beyond just the incredible results that programs have reported on in keeping people in their homes and keeping evictions off of people's records, reducing rent arrears, helping them get time to move, obtaining rental assistance, getting repairs ordered. All of those things have been reported on. This discussion we're going to have today is about results that haven't really been talked about as much in reports, but that are really significant and add a lot of value to right to counsel. So really quickly, what we mean by a right to counsel is a government commitment. So basically established in the law, there's an ordinance if you're talking about a city, or a statute if you're talking about the state, that's essential to it being considered a right to counsel. Funding alone is not enough to make something a right to counsel. It has to be publicly funded. That's a strong belief that we have. Some places have used temporary funding from other sources to try to get it off the ground, but ultimately this is something that has to be paid for by the government. Can't be done just by trying to lean on pro bono. That's also not an answer. It has to be government funded. It ensures an attorney for all eligible litigants, where eligibility is defined by the law in question. So it may be all tenants, it may be all tenants who are below a certain income level, it may be all tenants below a certain income level who have children. Those are decisions that are made by the jurisdiction, but as long as that criteria is defined and is objective, it doesn't leave any question as to who would be eligible, that can be a right to counsel. And it's full representation, basically, meaning that this is not brief services, this is not advice and counsel, this is an attorney who represents the tenant, who has that attorney-client relationship, and is doing whatever it is that's necessary to ensure justice in the case. Next slide, please. So there are many justifications for right to counsel, and in fact, today's whole session is to provide you some additional ones. But just to touch on some of the ones that we often talk about, the basic human needs at stake in an eviction are not just the housing itself, but if the person loses that housing, they may lose their children. Because their home may not be stable, they may lose their employment. If they have to relocate, they may lose their health, because evictions have dramatic health consequences. If they become homeless, they may lose their liberty. If they're incarcerated, they may wind up with a criminal record, and so on and so forth. We view evictions essentially as the shatter point for so many other basic human needs, that if you break housing, you break so many other things as well. Effectiveness of representation, I just alluded to that, but there's incredible data about that. There's also data about how much money it can save jurisdictions, because all of those consequences get avoided that I just mentioned. It's about equity and faith in the proceedings. These are proceedings which have a massive representational imbalance. 3 to 4% of tenants, over 80% of landlords have access to representation. The system itself is grossly unfair because of that. It essentially has adapted to basically expect the landlord to have representation and the tenant not, which is why the proceedings go so quickly. In some proceedings, in some places, less than 2 minutes per hearing. And also the race equity concerns of the fact that the vast majority of people going through evictions are people of color, especially women, Black women who are disproportionately in eviction court. We also know that it changes the behavior of system actors and increases tenant power, which normally I would go into, except, again, that's the subject of today's discussion. So we're going to talk about that today in much more detail. But basically, the right to counsel has many different kinds of benefits to it that have been proven and increasingly being talked about. Next slide. This is just an example of something that was done during the pandemic to try to get a handle on exactly how expensive evictions are. And it basically said, roughly $315 billion in costs are incurred by evictions. This was, again, during the pandemic when the numbers were a little higher. But even if you were to even cut this by, a fifth, cut it down to a fifth, it still cost the country greatly more than a right to counsel would cost if we provided it for every single person in the entire country. Next slide, please. This is just an example of one study that was done in one particular jurisdiction in Baltimore, which said that a $5.7 million investment would lead to a many-fold $35.6 million savings for both Baltimore and the state of Maryland. And that's the kind of thing that these studies have increasingly shown. Next slide. This is basically the progress of where we've been as far as the enactments of right to counsel. We went from 0 jurisdictions in 2016 and before, all the way up to 17 cities, 1 county, and 4 states as of 2023. We have some jurisdictions that are getting very close in 2024, including Los Angeles, which Pablo may touch on. But basically, as you can see, the progression has been extremely rapid, and in part because people are seeing the benefits that we're going to be talking about today. Next slide. Polling data also really significantly shows that across the board that there's support for right to counsel. This is one of the reasons I think that you're seeing it passing in more places, that there really is broad support for this concept. It's one of the few renter protections that really has this kind of support across the board. Next slide, please. We're not going to talk a lot today about the statistics from specific jurisdictions, but just to touch on a few of them, New York City has seen 84% of represented tenants staying in their homes. They've seen a reduction in defaults, which is situations where tenants don't respond to the complaint. They've seen a reduction in filings, same in San Francisco. Next slide, please. And again, this is just a representative sample. We have many more of these statistics on our website, but Cleveland, Boulder, and Kansas City all seeing a variety of different kinds of benefits, basically people avoiding eviction, getting additional time, getting rental assistance. It's just really being transformative of these systems where there was practically no representation before right to counsel, and now these incredible results being delivered to so many different tenants. Next slide. And this is just a representative sampling. We're working with over 100 jurisdictions right now across the country on right to counsel, everywhere from the South to the Midwest, to the West, everywhere, rural, urban, it does not matter. There's so much interest in this issue around the country right now, including both red and blue states, that we're really excited by this, by the diversity of interest. Next slide, please. Okay, so we can end the slide presentation now. That was basically a very quick overview. We have a lot more information about this on our website, civilrighttocounsel.org, but we really wanted to focus now the time on the discussion with our incredible panelists today. So I'm going to start us off by asking our panelists to talk a little bit about tenant power. So this is basically, we know that right to counsel helps tenants avoid eviction. That's what the data has been showing us. But what we want to talk about more is how does it affect tenants' power and the way that tenants think about their rights even before they're in an eviction proceeding. How does it affect them? How does it affect tenant organizing? So I'm going to ask Pablo to start us off and give your perspective from both New York and Los Angeles to the extent you would like to.
Thanks, John. Good morning and good afternoon, everyone, based on your time zone. So yeah, I think I'm thinking back of when I first started organizing in the Bronx in 2013. I started out as a tenant organizer, so my main role was organizing tenant unions in the Bronx. And the frequent concern that I heard from tenants was like, what happens if I assert my rights, right? What happens if I ask my landlord for repairs? And there's always that frequent fear of retaliation, harassment, and being sued. And so I think once we had right to counsel, it allowed me to organize tenants in a different way of, you can stand up, you can exercise your rights, and you will have a lawyer there to back you up and support you. And that really helped change the game for having more people feel empowered, feeling like they were supported, and exercising their basic rights to get repairs, to get basic services like heat and hot water in the winter and more. And I think it also increased tenants' confidence in taking action if they were in the right, because often it feels like, landlords have this power, what they must say must be true, but that's not right. In my experience, most landlords don't actually know the law and are actually violating it a lot of times. And then, going from a building perspective to a larger movement perspective, once right to counsel was passed in 2017, I think that was really critical to building a mass movement of tenants in not just New York City, but across the state of New York. And then if we fast forward, to the beginning of the pandemic, one thing that was realized was that was a big deal was on May 1st in 2020 in the pandemic, the New York City Right to Counsel Coalition was able to help coordinate the largest rent strike in 100 years. And there was 57 buildings that went on rent strike, and all of those buildings had attorneys that were going to represent them in the rent strike. And part of that strategy was also a larger thing. It aligned with the national movement demand of we need to cancel rent, right? And so, I do want to say a lot of the rent strikes were successful. Some of them we can't really talk about because, the settlements have non-disclosure agreements. But I want to say that, tenants, one building was on rent strike for 18 months, and they got a pretty favorable settlement in which, the goal of canceling rent was halfway realized. So I hope I got around that legally. But yeah, it was definitely critical. And I think the last thing I would want to say was, having right to counsel itself helped us build up a tenant organizing infrastructure across the city, right? So, when I was in the Bronx organizing at CASA, it was just a few organizing groups. But as the movement grew, as we had right to counsel, organizing expanded across the 5 boroughs. Well, Staten Island was always very difficult, but across the other boroughs, it expanded tenant organizing, new groups formed. And yeah, I want to say I'll stop there.
That's great. And I think what I hear you saying is that the tenants both were more confident in asserting their rights and more confident in getting engaged in organizing in general, in being in an organizing group, because I know that a lot of tenants fear just being in an organizing group might subject them to retaliation, even if they, putting aside any rights they might try to assert. Is that your experience as well?
Yes, exactly. And I think the other thing you just reminded me of it just allowed us to dream bigger, right? So beyond right to counsel, it's a critical protection and right that people should have, but there's also a lot of other things that we needed to win in the housing justice movement, right? We still had the issue of lack of enforcement for landlords, right? Landlords often get away with not making repairs. So it helped build that, from New York City to New York State. In 2019, there was the rent loss fight, which was a big deal. Previously, New York State has a lot of rent regulation, mostly concentrated in New York City. But in 2019, there was a big opportunity to win further reforms and strengthen the rent law system. And we were also able to do that. Out of the 9 different state laws we were hoping to strengthen, we passed 8 of them, basically. So that also really helped, I think, turn the tide. And in New York, we all know that the real estate lobby has a really big influence. And so, that was also very historic to be able to strengthen the rent laws when landlords had been scaling them back over over previously 2 decades. So yes.
And it's also worth mentioning that the Real Estate Board of New York actually has endorsed the Right to Counsel campaign, the statewide Right to Counsel legislation. So showing how the force of all of that organizing has actually even shifted the position of what a group that probably historically would not have been very supportive of Right to Counsel. Ora, would you like to talk about it from the perspective of San Francisco?
Absolutely. And mostly what I can do is really echo and validate what Pablo shared and say that we've seen the same thing replicated in the San Francisco Bay Area. Our rights as tenants are only as strong as what we stand up for. So California in general and San Francisco in particular have some very strong tenant protections built into our ordinances. But if as a tenant, I fear my powerlessness, the risk of retaliation, I'm not going to stand up and assert those rights. So what we've done by having a right to counsel is we've told our tenant community, not only do you have protections, but you have folks who are going to step up and help you assert those protections. And that's given them a greater confidence to be able to say, yes, I am going to complain when it rains in my living room. Yes, I am going to object to illegal rent increases. I'm not going to be fearful of retaliation because I know I will have somebody as my advocate if I have to go to court and assert those rights. Especially, I would say, in the undocumented immigrant community, where rightfully and understandably there's a great deal of fear and risk of retaliation. We have always had, well, not always, but for a significant period of time, have had protections on paper that says landlords aren't allowed to assert that. That's not even going to be mentioned in court, but now they have greater confidence and support from an attorney. So we're able to really do a better job of asserting those protections. Also in the tenant organizing arena, the timing after our right to counsel passes, not that long after, a few years later, we also have a very unique and original ordinance in San Francisco, which is a tenant right to organize statute. We're very excited by it. We love telling people about it because we hope you'll replicate it and spread it across the country. It's modeled very heavily off of labor organizing principles and creates an absolute right of tenants to organize not only within their building, but across properties. And there's certain mandates about requiring the property owners to negotiate in good faith with these organized tenant unions once they're established, to provide meeting space in their buildings, to prohibit retaliation. So there's a lot of protections built into our right to organize law, including rent board petitions for decrease in services should the landlords violate those laws. And it's working in sync with our right to counsel because the organizers of those tenant unions are now able to rely on, as Pablo mentioned, on sharing with folks, don't worry about retaliation. We have your back. We have attorneys who can work with you. And most specifically, we have as a model, the example of our VTA. It's the Veritas Tenants Association. Again, I think this is replicated all around the country, but in San Francisco, the mom and pop small landlord really is a disappearing species. And what we have is very large corporate entities and LLCs that are taking over the property ownership. And their model is to maximize incomes regardless of the rights of the tenants who are living in there. Veritas is an example of that. There are others. There's Green Tree and Brick and Timber. And this tenants association was able to organized across all the different Veritas properties, engaged in a multi-year rent strike that they never would have been able to do but for the backing of having tenant right to counsel to protect them. And I have to say that they've been winning. The rent strike has never been broken. They've been successful. A number of those Veritas properties, sadly, have been foreclosed upon. And the new owner immediately started talking directly with the tenants union and saying, you're right, we're going to fix the things that need fixing. We're going to talk with you and we're going to vindicate your rights. So we're chalking that up as a great success.
And I just want to put a note on you mentioned undocumented immigrants who, who are especially fearful in the eviction context, and the right to counsel is not restricted based on immigration status. It applies to everyone. And that's not true of a lot of other programs. And so that really, in jurisdictions where there are, the legal services corporation programs are not allowed to represent them. So in jurisdictions where there are LLC programs that are right to counsel providers, someone else does those cases, but they do not go untended. And that's really a significant piece of this puzzle as well.
Yeah, that's absolutely correct. I would just say our version of right to counsel has absolutely no eligibility screen whatsoever. Again, that's fairly unique. We don't have a financial screen. We don't have a documentation around immigration screen. If a tenant has eviction papers, they have a right to counsel.
And actually, none of the laws that have passed have any any immigration provisions in them at all. We wouldn't support that, and I don't think anyone would. Actually, there are now 6 or 7 jurisdictions that have no income limits on their right to counsel. So it's actually becoming recently it's become more of the norm to do that for reasons that we can talk about on a future webinar. Thomas, please join us.
Yes. So all I can really add is just to echo what Aura and Pablo said, and just relay some anecdotes from Connecticut, because definitely the right to counsel just empowers and emboldens tenants, knowing that if they are going to proactively pursue and defend their rights, that there is, a shield behind them waiting in case an eviction is brought against them. And just knowing that that layer of protection is there is huge, and it makes a dramatic impact, and just empowers tenants to, vindicate their rights. And I think a great example of this in Connecticut occurred, I'd say about 6 or 8 months ago. Last year, there was a tenant union that was negotiating with a big landlord in New Haven. And in the middle of the negotiating over rent, the landlord filed 16 notice to quits against 16 of the tenants in the building, and most of them were, leaders in that negotiation process. And it led it into a big protest where the tenants organized members of the community, different political organizations. Senator Blumenthal was able to attend the rally. So it was a big presence. And I think a real big part of the tenants union being so aggressive and proactive was knowing that New Haven Legal Aid was there to defend them in the eviction actions. And New Haven Legal Aid, which I'm in the greater Hartford Legal Aid, but the New Haven Legal Aid, they were ready and able to help. And fortunately, because of all the public outcry and knowing that New Haven Legal Aid was there because it was clearly retaliatory, the notice to quits were withdrawn. So that was a big success. And that wouldn't have been possible without right to counsel, because the tenants, as I've said before, just feel more empowered, more emboldened, knowing that legal aid organizations are there for possible adverse consequences from the landlord. And that is absolutely huge. And also, I mean, for tenant power, once you have right to counsel, once you kind of open Pandora's box and a state or government entity decides to start assisting tenants, you kind of realize that right to counsel is just the first step in a sense. So after Connecticut passed right to counsel, now the city of Hartford has a program regarding conditions and helping attorneys proactively do conditions cases. And, I don't think that would be possible without right to counsel, because again, once you see that, having a lawyer is helpful, but it doesn't solve the issues that we're seeing here, then you have to, take further steps to address the great power imbalance. So it really opens up the door and shifts the Overton window more in our favor.
Thank you so much. I want to point out something that's really interesting here, which is that New York, San Francisco, and Connecticut were all major organizing victories for right to counsel. That's not necessarily true everywhere. Sometimes it's been more legal aid or other groups that have pushed. But in these three jurisdictions, it was organizers, the DSA in Connecticut, Tenants Together and the DSA in San Francisco, the Right to Counsel New York City Coalition in New York City. And one thing that occurs is that right to counsel is a winnable victory. It's something, clearly it is. There are 22 jurisdictions that have gotten it. And that itself can actually build tenant power. When you win a campaign, that creates confidence, that creates inspiration to keep going on other issues. I don't want to speak for organizers, but it just occurs to me as an attorney that I don't know, Pablo, if you are an organizer, would you say that it does work that way for you or in what you see?
Yes, definitely. I think the experience of having that victory, in New York City, it took 4 years, but having that, a lot of the tenant leaders have that experience and that victory also, I think, opened up the possibilities, right? And allowed us to dream bigger in New York, to be able to win the rent laws, to be able to win a statewide eviction moratorium. So yeah, definitely agree.
Thank you. Well, we're going to move to our next point, which is the way in which right to counsel causes changes to the system. And the system can be things like the way that the landlords behave, the way that the judges behave, and the courts behave, the way that rental assistance programs behave. There are a lot of different things that a lot of sort of system impacts that right to counsel can cause. So we'll start again with Pablo. If you want to talk about what you saw in New York, that would be great.
Yes, and a little bit of history, y'all. The interesting thing about New York City was that housing courts were established in 1973. It was actually a tenant victory, something that the tenants were demanding, because they weren't getting a lot of repairs. So the true intention of housing court was a place for tenants to sue their landlords to get repairs. But obviously that changed over the decades where it just became an eviction mill. And so we're looking at 2013, in the Bronx housing court, there's 21 courtrooms. One is only for cases for tenants to get repairs, and the other 20 are just eviction courtrooms. So definitely the whole reason for housing courts was changed, and it was an awful system. And going back to the point of, I really do believe that a key reason that in New York City that we were able to win right to counsel was because the coalition was tenant led, and it focused on tenants really leading this campaign. And a prime example of that was, the year before I started organizing at CASA, the community members at CASA decided to focus on housing court because evictions was one of their primary concerns in the Bronx that they saw as a top housing issue. And so CASA spent time training community members on how housing court functions, collected surveys, and this led to the publication of a report called Tipping the Scales. And in that was really when the campaign got launched, and the main focus was right to counsel. If we win right to counsel, this will be a game changer. But there's also a host of other policy recommendations based on how we saw court function, right? Housing court was dysfunctional. It was a hostile experience for tenants, right? And a lot of folks in the Bronx are also undocumented, are immigrants, speak many languages. There's a huge West African diaspora living there. So folks might not even be able to access an interpreter in the language they need. So it's really a terrible experience for tenants to go. You're going through a security line in the morning. You can't bring in food. You don't have childcare. The court staff aren't helpful and already judging you for being there for an eviction case. And so I think part of right to counsel, we're focused on right to counsel as passing the law, but we also were focused on changing the culture of housing court, because it was not just awful for tenants, but also the tenant attorneys. And so, y'all probably know that, it was a bad environment. Tenants were being pressured in hallways by landlord attorneys to sign unfair stipulations. The judges were lenient towards the attorneys, the landlord attorneys, right? They showed up late, they would never get defaulted. If a tenant showed up late and got called up, they would get defaulted and lose their case automatically, right? And even worse was just kind of the treatment of tenants for the landlord attorneys. Often, tenants share the sexist, racist remarks that they make towards them. And so landlord attorneys really felt like they have the power in the courtroom and tenants don't. And so one thing that happened was there was a group of attorneys, once right to counsel happened in 2017, there was more tenant attorneys, and that started to shift the balance of power in court, right, towards tenants and the attorneys. But I think one significant thing the tenant attorneys did, many who are young, it might be one of their first jobs coming out of law school, were experiencing that same harassment and unprofessional treatment and, racist, sexist remarks. And they published an open letter to the judge, which allowed them to start meeting. So the supervising judge in the Bronx would regularly meet with legal aid attorneys and then the landlord attorneys and chastise their behavior. So I do want to say we saw an effect there that was also about changing how housing court functioned. And right to counsel had some really immediate impacts in 2017. In the first year, there was 50,000 less eviction filings. New York City is the number one city in the country that faces a high volume of evictions. So to go from like 220,000 in the first year and less than that it showed the power of right to counsel, right? It also deterred landlords from even filing eviction cases, because the eviction filing fee in New York City is low. So landlords were oftentimes filing frivolous list cases, right? They would keep filing the same case for the same amount of rent, even though that was taken care of. So that was just a little bit of sloppy work, and It also drags the tenant back to court for no reason when the case already got settled and the tenant proved that they paid the rent or got the rental assistance. And so, yeah, I think we saw all those changes, you know, the environment of court. And then one thing that was surprising that John mentioned earlier was not only did the real estate board endorse right to counsel, we also had the chief administrative New York State judge at the time, Judge Fisher, I think, I got it wrong. But the previously top judge in the state of New York endorsed right to counsel as well. And then I think once right to counsel started getting implemented in the courtrooms and housing courts, the judges there saw it as more favorable, that they also agreed like this is a more fair process, having both sides have legal representation, being able to actually litigate a case, file motions, etc. Yeah.
And in fact, they testified to that effect in a hearing in New York, which we can drop the link in the chat too. But that, you know, I think for a lot of us, we never thought we'd see the day, you know, of that happening, because in some jurisdictions, the courts are actually more vociferous opponents of right to counsel than the landlords are. Unfortunately, it's, you know, really a sad state of affairs to see the judiciary that opposed to tenants having access to justice, but that is what we see in some places. Ora, do you want to work off of what Pablo said?
I do, and I'll start just tagging on to your last comment. We don't have a court that will come and testify on our behalf, regrettably, that we're not at that level because of their belief that that is contrary to their ethical obligations. But we definitely have a court that appreciates the presence of right to counsel. We have made the court officer's life much easier than struggling with a 90% rate of self-represented litigants in the landlord-tenant world, which was what we had prior to right to counsel. And as frustrating and difficult as it is to be a self-represented litigant in this foreign environment, trying to navigate one of the biggest crises of your life, which is risk of shelter, the court personnel also struggled with that, and particularly the ones who actually cared about justice and a positive result. So they are thrilled that we exist. And they will sometimes call and outreach to us if somebody failed to get into our system and the court clerks notice them wandering about. They've gone bent over backwards to make sure that we connect with each other. And we also have regularly quarterly meetings now with the court. So the existence of right to counsel has not just changed the power balance on a day-to-day way with each case that's standing in front of the judge, but we're able to weigh in on court systems and court processes. The landlord bar is also present at these meetings, as is our funder, which is the Mayor's Office of Housing and Community Development. And we have discussions every quarter with the court about problems that the judges are perceiving and how things are going, problems that we see. And we're bringing in many issues and concerns that otherwise would not have been addressed. We're finally having a forum in which we could bring that up. We also are able to use our power to weigh in with legislators where we've become the go-to resource. So although with emergency rental assistance programs, which became much more robust during COVID, but still exist, we are consulted regularly on how those should work. The city's managed permanent supportive housing programs, we're consulted about policies that should be put in place on those. So we've become the known experts on housing law, even though we know that what we're doing is advocating for the tenants and occupancy. It's great that our voice has become an important voice in the room when these kinds of big decisions are being made. John shared a stat early on about eviction rates being down just prior to the pandemic and defaults being down. I'm sad to say that that's not what we're seeing any longer. It's hard to know if the big bump right now is our post-COVID flood or whether that's what's going to be happening down the road just because of changing economics in the city. But it's no longer true that neither our eviction rate nor our default rate are currently down to the levels that we'd like to see them. But at least those folks are getting representation. The other thing is, because we're sort of a one-stop shop, there are 8 legal service organizations participating in our right to counsel program, but they're all under one shared umbrella. Our agency, EDC, is the lead agency, and we have a shared data bank. We touch every eviction that's happening in the city, and this access to data it's a gold mine that we could share with each other to make systemic changes, but also with the media, with tenant organizers, anybody advocating for change. There's a new Bay Area organization called BAFA, which is trying to do a Bay Area-wide addressing of homelessness issues. The data that we have is rich, and we're just beginning to touch what we could do with it. Identifying who are the worst evictors, identifying why some of the supportive housing units never are in court, and some of them are in court every week, and how we could address and fix that. And also something that we'll touch on later, because we're this sort of one-stop forum for shopping, we are getting more coordination between the organizations, and we can be clearer on what our stipulations will and won't be. We're getting more favorable settlement terms just because they know that we'll go to trial. And it's affecting settlements across the board, even in cases that aren't being represented by us. So it's a very, very powerful tool. We've also been able to step up. There's a concept in California of what's something called a vexatious litigant. That's somebody who is self-represented, and to get somebody declared a vexatious litigant, you need to show they represent themselves, and during a 2-year window of time had more than 5 cases that went to a negative result for that litigant. There are some self-represented landlords and, quote, agents of landlords who are basically practicing law without a license that for 20 years we've wanted to shut down. And now we have finally had the data to do that. And just a few months ago, we're able to have one of them declared a vexatious litigant, which is pretty much shut down her business. So we're very excited about that type of work that we're able to do just because we have these systems in place now.
It's incredible. It's really incredible. Again, you know, when we talk about the data, 3% of tenants represented on average prior to right to counsel. So how much data are you going to get when lawyers are there so infrequently? They just can't. There isn't enough representation to really get the information that you need. And now you're getting lawyers every day representing, in some cases like San Francisco, everyone who's there. Everyone's eligible. Thomas.
Yes. So as one of those fairly new attorneys that Pablo referenced, dealing with the landlords on a day-to-day basis, and their attorneys, I mean, they are often quite rude and disrespectful. So we should talk at some point to figure out how to combat that, because that's definitely not something that's improved. Maybe it's gotten worse because they get more frustrated. But yeah, so I do think we're seeing a lot of impacts here. In cases, like Laura said, where we're not even representing the tenants, I think we're seeing a lot of landlords' attorneys do a 30-day notice to quits as a matter of course, because they know that the CARES Act exists, and they know that if they do a lower one and they somehow mess up, their client doesn't give them the correct information, I mean, that's an easy motion to dismiss that we can catch. So they know, they're often quite lazy. They don't want to do the work of doing the research, so they just do a 30 days. And so now that they know that we're out there, looking for mistakes like that, they just kind of do it. And that extends the time that tenants get, even ones that we aren't representing. I think also our presence in the court, and now that there's a critical mass, because there has been housing attorneys before right to counsel, but now that there's more housing attorneys in Hartford, I do think that the courts are slowing down a bit. And not, it's still kind of an eviction mill, but now that we're there and making sure that the landlords have to cross their T's and dot their I's, it is slowing down the process, because if we don't get discovery by a certain date, which landlords attorneys are not used to providing, we'll just continue the case, and then that slows down that case. And because cases are getting continued, the docket's getting filled up. I do believe, I don't have any data to back this up, but I do think there is a slight impact of slowing down all cases. The deadlines are pushed back for everybody, because the court is scheduling a month and a half in advance. And I do think there are, trends that we're kind of helping strengthen, back to discovery. Landlords attorneys are not used to providing any documents. They're used to showing up at court. Oh, here's the ledger. Here's some figures. Do some math. some magic, and then boom, that's how much you owe. But now that we're doing discovery in advance, asking for leases, asking for, allegations of nuisance to be documented, to be verified, I do think that landlords' attorneys have fought back quite a bit on that, kind of protested, thrown fits that we're asking for the bare minimum of documents. And while I wouldn't say they're entirely compliant now, I do think that we're establishing general practices that like discovery is a standard process in, or more, should be considered a standard process here. This is, housing court is still a real court. You still have to, follow the rules, and you can't just bring documents and surprise people. So I do think we're seeing a lot of changes that are not just impacting the tenants that we serve, but all the tenants in the Hartford area, and I believe Connecticut generally.
There was a question in the chat that I think it's worth taking really quickly, which is the right to counsel is not just at the courthouse. You're developing the cases, able to secure witnesses, ensure correct paperwork is in court. This really goes to like the timing of essentially when you're offering assistance. Do you want to just touch on that, Thomas, like how or how it's working in Connecticut and in San Francisco?
Oh, sure. So I can talk about how my experience in Hartford. So in Hartford, I believe this is fairly common, but we have mediators who we speak with and try to negotiate the case, or they try to facilitate negotiations between us and the landlord. And I do think that because there's more of us, we've been by being a bigger player and kind of being like an established fixture of housing court, the mediators now know to come to us for certain cases. So if a person has a especially egregious case, mediators will often reach out to us and tell us that there's kind of a case here that should be monitored, and that if we are just hearing of that case, we can often get them to ask for a continuance to get legal representation. So that can be helpful in those cases where somebody is realizing that they really need a lawyer kind of at the courtroom steps. So often they can get it if, assuming it's like the first court hearing. I mean, that's not perfect. I mean, I do wish that like we could have like almost like an office at the courthouse, kind of more established where people could swing by. But I don't think we're quite at that level of like staffing or like relationship with the court to get to that point. But maybe one day, because I do agree that that would be helpful to like really be even more of a fixture where like if anybody has any housing questions, they could swing by our office at the courthouse. But we also do handle a lot of cases where an eviction order has been issued. Those are executions, and we are able to file emergency paperwork to like stay those and often get the martial orders quashed. So again, that's not perfect because those are cases where the person has come to our office. So those aren't like proactive outreach efforts, but they are people who are coming to us in kind of the last moment. And we are often able to kind of get the paperwork and at least get them some more time, or maybe even get it taken out altogether. So those are kind of some of the ways that we try to handle and address some of the cases that we don't kind of see from start to finish.
I think we will do some more follow-up on this question after the webinar. We'll include it in our written outreach to everyone after the webinar, because there is a lot to say about this. But just in short, the programs generally all reach out to tenants before the courtroom. They're not waiting just to get them when the court. Many of the right to counsel programs have an in-court presence. Some of them don't, to catch people who are not, caught beforehand. But yeah, basically the answer to the question is the right to counsel is not generally just at the courthouse. It's intended to start earlier than that, and does in most places start earlier than that. And we'll elaborate more on that question, because it requires some explanation after the webinar. So we're going to move on to our next discussion topic, which is how right to counsel has led to reform of the landlord-tenant law. This is something I think that is really, really important. And so How has this played out, Pablo, in New York, or how did it play out in New York, in terms of changing the law itself?
Definitely. So one key thing that comes to mind that allowed us to be able to reach tenants that were facing evictions was having a state law that made eviction records more public. And so that was, that's a tool that we can now use that was developed over the years to be able to see which landlords were filing cases. And I think as Aura mentioned, back when I think about my tenant organizing, we were often targeting corporate landlords, right? In the Bronx, like Finkelstein Timberger comes to mind because he was my primary target in my organizing days. But it allowed us to see that these corporate landlords were not only just filing a high amount of eviction cases, but they're also illegally raising rents. They were doing major capital improvements to raise rents through the state law and denying services, repairs, construction harassment. So having eviction data more public allowed the Right to Counsel New York City Coalition to actually start publishing a yearly worst evictors list. And also, the public advocate at the time, an elected official, I don't know if y'all have public advocates across the country, but the specific New York City elected official is kind of there to, defend the public good. They also published their own worst landlords list based on eviction files, coded violations, all of which are public things. So I think that allowed us to really target the worst actors, and really stop that behavior and stop the evictions from happening, and making sure that the resources, we didn't have right to counsel right away. It was zip code based. So it allowed us to also utilize resources in a more intentional way. And it made it easier for us to organize tenants, right? And then, landlords hated that they were not just on the public advocates worst landlords list, but also on the right to counsels. They've actually emailed the coalition to be like, hey, can you please take me off? I'm a good person. These tenants aren't just paying rent. So there is that power in the public shaming, allowed us to be more strategic about which tenants we're organizing, which landlords we were targeting. And yeah, it was a yearly thing. And then I think currently right now, there is a tool that was published by ANHD where you can look up like any property in New York City. You can see who the landlord is, thanks to some of the work that Just Fix New York City has done to unveil the landlords through, how they hide through multiple LLCs and track them. So you can look up an address in New York City right now through this tool, see all the violations, and you can also see who's been evicted. So you can actually get to folks in real time right now, which is pretty great, because y'all know the court process is still pretty quick. And I think one of the, to John's point about what law reforms we also saw as part of the rent laws fight. It wasn't, one of the primary things we were talking about, but part of the 2019 rent laws included state reforms to give increase the notice time for landlords. So this was particularly good for unregulated tenants, market rate tenants. So instead of just getting a 30-day notice, based on your tenancy, you'd either get 36, or based on the length of your tenancy, like the longer you live there, the more notice the landlord had to give you to move out. So if you live there for more, like, I forget, but you got up to 90 days, which helped, right? Because often evictions are really quick. Tenants are shocked, don't know where to go. So that extending the notice requirement before being able to file the case was helpful. The state legislature also doubled the amount of days you have to respond, from 5 days to 10 days. And also another key thing was outlawing the blacklist of tenant screening. So which, y'all know, once people are evicted, it becomes a stain on their record, and landlords often use the screening to look at, to deny tenants the ability to get a new home. And yeah, I mentioned these, so that was part of the rent laws. I do want to mention that one historic thing that did happen through building power, through organizing, was that we had an eviction moratorium, one of the strongest ones in the country. And in the 18-month period, less than 50 tenants were evicted in New York City. And so, at the New York City Right to Counsel Coalition, we always had this vision of eviction free, like what it would look like if we could get to a world where evictions didn't happen. And I feel like we realized it during the pandemic, because that was a big organizing window opportunity for us in the movement. And I want to say, like, in Los Angeles, we don't have a codified right to counsel, but we do have a Stay Housed LA, which is program, which is like the pilot. So there's eviction. There are attorneys. There's about 70 of them right now, and there's a lot of outreach and education happening through canvassers. So I do want to say we don't have codified right to counsel, but I do want to say that one thing that we've recently been able to win in Los Angeles City in the last year is that landlords can't sue a tenant if they owe less than 1 month of fair market rent. So that's been a pretty big deterrent to stopping landlords from even filing those cases. And then, there's been some rental assistance programs here in LA City, but sadly, we're seeing a lot of landlords reject them. So we are working on making that, the discrimination, passing a law against subsidy or source of income discrimination. But I do want to say there's wins across the board, and it's allowed us to just build our power and keep winning.
That's great. I'm actually going to go slightly out of order just because of a question in the chat. There was a question about our right to counsel programs helping tenants seal their records. And I know that in Connecticut, there was some reform around eviction records. So Thomas, do you want to speak to that?
Yes, so I think a big part of right to counsel is that there's more attorneys involved in this field. So there's more of a critical mass where attorneys are able to catch issues and see problems on a systemic level. And a big issue that we were seeing in Connecticut was that even if you won and it was a completely frivolous eviction case, that it would still be on the tenant's record for a year. And that was a real big hard point of leverage against us, because a lot of our clients really want to preserve their eviction record. So working out some sort of situation to avoid that was really difficult. So fortunately, because of this issue, and we know people were able to notice it, there was legislation passed last year that goes into effect this year that'll have cases where the landlord withdraws or the tenant wins a trial. They'll only be on the website for 30 days. So that's a massive change. It going from 1 year to 30 days is really quite dramatic, and that's going to help us out so much in our cases where we win, and we can assure the tenant that it's going to be off the website in a really timely manner. I mean, I guess the next fight will be making sure that these evictions aren't still impacting the record, even if they're off the website, when these programs are kind of grabbing all that data and keeping it. But that's the next step. But yeah, that was a big change, and I think right to counsel played a really important role. Also, we have often, when we come to settlements with landlords, it counts as a judgment. And we have this kind of complicated procedure where if, let's say, we're doing a reinstatement agreement and it's a judgment, it would technically be on there for a year, but we're often able to negotiate that as long as the tenant fulfills the conditions of the stipulation, and they're reinstated, we can file a motion to open and then it'll be withdrawn. So that'll take it from a year to 30 days because the case ends up being withdrawn. And I do think that in cases where the tenant isn't represented, they'll still get that provision, but often our clients are so busy and they don't want to go through the effort of going to court, taking time off of work to file that motion to open and get it quickly off, or they forget, which is totally understandable. They got a million things going on. But in cases where we're representing them, we're able to be on top of that, put on a calendar after this date, remove it from the court website. And I think that's a big deal in all these cases. And just to, at one point, this is separate from the sealing and the records retention, but just talking about the effect on the law. Again, the critical mass is very important. Right now, Connecticut, we're really fighting to extend just cause protections. And our advocates in the State House, often get a lot of questions and they're fielding inquiries. And because there's so many attorneys involved in right to counsel, we've really developed quite a network where these questions can be easily answered. An advocate gets a question from a legislature, they can send it to the email listserv of all the right to counsel attorneys in Connecticut, and they can get an answer quite quickly. And obviously, that's not just right to counsel alone, but that's a really big impact that there's so many attorneys involved in these issues and inspecting them. And finally, Hartford, we're pursuing litigation against the housing authority because of a rent calculation issue. And this was a systemic issue of them miscalculating rents of people who didn't have any income. And right to counsel is helpful in capturing that issue because we had attorneys here and there were more attorneys who were able to notice that issue. It wasn't just a one-off, oh, like I'll address this in my case. We all saw the issue and realized that it had to be addressed not on an individual client-to-client basis, but had to be proactively addressed against the housing authority. So we're really happy that we're pursuing that class action. And I think that's a result of the impact that right to counsel is having in Connecticut.
Yeah, and I think this is a common theme, that the issue spotting, when attorneys only occasionally appear in housing court, they don't see patterns. And the patterns are what you need to see. If you want law reform, you have to know what things are coming up over and over again. Or if you even want to, as Pablo referred to, if you want to target certain landlords that are the worst actors, you don't really get a sense of that if you're only occasionally appearing in court. But if you're there all the time, you start to see what's what in housing court and who's doing what and what really needs to change. And that's what systemic representation and right to counsel give you. Aura?
Yeah, I agree 100% with John's most recent comments, and that's what we're seeing in terms of how we're able to affect the law reform and systemic change. I would say the two main key points that I've already mentioned that allow us to do this is our very rich data that we're accumulating and the fact that we now have a seat at the table when we didn't used to have one, and that's all due to the fact that we now have right to counsel in San Francisco. Some very specific target examples. So one is the issue of masking that Thomas was already talking about. In California, there's a statewide masking law, which says that unlawful detainer cases are sealed for the first 60 days and remain sealed unless they go to judgment within those 60 days. So one of the things that we are able to focus on is to make sure that no case goes to judgment within 60 days, so they're permanently off our client's record. The way that a growing number of landlord attorneys have started to get around this law is it only applies to cases that are filed in what we call limited jurisdiction. We have a limited jurisdiction court and a court of unlimited jurisdiction, which is meant for the much larger cases where the amount of controversy is over $50,000. And the ability to reclassify a case is very difficult. We'll lose those motions. We've tried. And they're being filed in unlimited jurisdiction because they're not masked. And it's giving the landlords a tool in settlement negotiations to try to coerce our clients into less favorable settlement terms in exchange for a stipulation that the case will be resealed. So we're able to see that problem, how much it's escalated and become worse, and we're able to use our data to create legislative change at the statewide level. So we're working with our colleagues all around the state, and we have some legislation that's going up this year to extend the masking provision to the unlimited jurisdiction court cases. And so that's not just going to protect folks here in San Francisco, but all around California because of the patterns that we were able to see. Another example of patterns that we saw is that there was one landlord, and by landlord, I mean one of these very large corporate entities that was engaging in an illegal late fee practice. They had relocated from San Francisco to Texas, so tenants that used to pay on site now had to mail in their rent, and the rent that was being mailed on the 1st wasn't getting there on time if the rent was due on the 1st. Well, some of us might remember way back to our 1L contracts class, there's something called a mailbox rule, which says that when you stick it in the mail, you've performed. So actually none of those tenants were late and they were still getting late fees. So we were able, first of all, to defend all of those cases and keep the tenants housed and get rid of the late fees. But also we shut down the practice altogether. We were able to call it to the attention of the task force of our city attorney, and they brought claims against those landlords to completely eliminate it, not only for the clients that we were helping, but for all the clients who weren't fighting evictions or bringing it up as an issue. We've also been able to work in coalition with some other local organizations to pass some stronger tenant protections. So we're the member of a fairly unique umbrella organization called the San Francisco Anti-Displacement Coalition. And what's interesting about the Anti-Displacement Coalition is it includes folks like us, legal service organizations, but also tenant organizers, tenant counselors, and some of the housing providers also participate in that. So people who would sometimes be arguing with across the courtroom are now working together with us to create change with our shared goal of avoiding displacement. One of the new laws that we passed was the requirement of a 10-day notice. So in all fault evictions, there is now a mandate in San Francisco just cause protected homes, which is basically any unit other than those which are government subsidized. The landlord has to give a 10-day warning that lets the tenant know that there's this problem in place, give them an opportunity to fix it, mediate, try to address it, and only if it's not cured within the 10 days can the actual eviction process begin, which might again be with a new notice to cure. This is even before the official notice to cure. That legislation immediately, of course, was challenged in the courts, and it's still up on appeal, but pending that, there's an interesting ruling from the court that said it was preempted on non-payment cases and applies to all other fault evictions. The logic escapes me because either it's fully preempted or not at all, but we're living with the result pretty happily because most fault evictions, with the exception of non-payment, are coming within that exception, that requirement of a 10-day notice. And we've actually won a number of cases because of the landlord's neglect to provide that. Something we're particularly proud of is we inserted a particular word into that legislation. During COVID, there was a lot of exceptions for health and safety purposes, and we knew that this wouldn't pass without that exception as well. So the 10-day note warning is not required if there's a risk of a health and safety problem. Because during COVID, those health and safety cases suddenly became something that every truck was driven through, that where landlords used to evict for other causes, all of a sudden everything was nuisance all the time. We redefined health and safety as requiring an imminent risk to person or property. And we actually won a trial recently where the judge found that the risk was not imminent because of how long the landlord delayed from the activity to beginning the eviction. And so a word that we were able to insert into a new statute that we wrote saved that particular person's housing, and we were particularly excited and pleased with that. We're working on some new projects now, including avoiding forfeiture. New York has a lovely law that other states have, that the tenant can cure the eviction anytime up to the sheriff throws them out. We had that briefly during COVID. The world didn't come to an end. We're trying to get permanent statewide relief from forfeiture as something we could get past.
Yeah, and it's, one just a quick thing I'll say. I mentioned the Legal Services Corporation before, and folks, there are probably people on this call who work for LLC orgs and say, well, we can't advocate for policy changes. So like, what does this all mean to us? Well, the answer to that is you're seeing the problems. And if you write a report saying, here are the problems in housing court, which you're allowed to do, you're just analyzing housing court, other people can take that and decide what to do with it. There are other advocates who could pursue legislative reform that you're not allowed to pursue, but you have that information. And if you're able to synthesize that and put it into a report, it may be that someone else is able to decide legislatively that they want to take action with that. We only have about 5 minutes left for our last topic. So I'm just gonna ask you each to really briefly touch on the last question, which is how has right to counsel improved the way that legal aid functions in your jurisdiction? Pablo, do you want to start us off?
Sure. Extremely critical in New York City. The lawyers weren't really talking to each other. There's, nonprofit world, there's competition for scarce resources. But once the coalition was founded, one of the key things was the structure, making sure everyone had a role. It's tenant led. There's tenant leaders on the steering committee today. But one thing that was successful was that there was a clear decision-making structure. There was a working group of attorneys that created the implementation plan. And, we're thinking about, like, once we pass right to counsel, how will this impact court and how should tenants be able to access it? And yeah, that's it.
Well, right. And I think also you've mentioned when we've spoken before that in Los Angeles, it's really helped bring programs that might have been in conflict before, like sort of coming together on a shared vision because they're now part of the same campaign.
Yeah, it's led to, I want to say, New York City and LA overall, like, increase not just like coordination and regular meetings about right to counsel, but also other campaigns, right? And in LA, as I mentioned before, we have the Stay House LA program right now that we're advocating to turn into, right to counsel, an ordinance. But there are currently 13, well, I think it's 15 CBOs now, community-based organizations that are doing a lot of organizing work, and 12 legal service providers. And yes, there's regular meetings. In fact, people feel like there's too many meetings and too many working groups. But it is a big project, right? To get to fully realize right to counsel 5 years from now.
And in Aura and San Francisco, I know you have this UD school that I think people would be really interested to hear about now that as a result of right to counsel.
Yeah, so we already, unlike what I hear about New York, we're more friendly in California. So we already had a pretty amicable relationship and a pretty robust tenant advocacy movement, but right to counsel really was a game changer in a way that we now have 8 participating legal service organizations that regularly coordinate and speak with each other. One way that that's important is that we share this data that we mentioned. We share legal strategies. We'll no longer enter into a settlement agreement where we know that our friends down the street got a stronger stipulation with better terms. So we're making sure that the opposition counsel knows that none of us will stipulate unless this term is in there. And so that we're getting better results for our clients as a result of that. We're also, there's a small pot of people able to do this work, and we're working together to not poach each other's attorneys, but instead have the shared goal of making sure the tenants get their representation. But something we're most proud of is what John mentioned, which is our UD school. Instead of having to like reinvent the wheel and each of us use our limited resources to training up the staff, we're all bringing in a new cohort. We realize at the same time, law school graduates finish up in May, they take the bar in July, and we all try to bring in a new cohort every September. So we, across our 8 agencies, are doing a shared training program. We have about 20 students in our UD school now every fall, and we coordinate the training with the most expertise supervising attorneys from each of those 8 organizations. We have an intensive program for 3 days in September, and then follow-up one-day refreshers throughout the rest of the season until we have the housing justice warriors of tomorrow all trained up, either that we will retain as our staff attorneys or send out to all of your agencies, highly trained. It's great because it means it's a sharing of resources. It's great because it's increasing the quality of who we're training. We're all on the same boat. And it's also creating sort of across these agencies, they're creating their own cohort with each other. So they're getting the support of being new attorneys and getting both that legal support, but also emotional support. So it's working well for retention issues also.
And Thomas, the last word, I know you sort of referred to, you've referred throughout to sort of better coordination between your different programs in Connecticut. Is there anything else you'd like to add before we wrap up?
Not really. The critical mass just allows for better coordination, more emailing, more sharing of case sites, issue spotting. It's just helpful in all regards.
Well, I want to just thank you all so much for this. I think you've shared just a wealth of information about really the so many ways in which right to counsel is impacting your communities, empowering tenants, leading to law reform, improving legal services delivery. All of it is, and changing the system, which ultimately is the goal of so many of us who are involved in this, is seeing an eviction system that is so fundamentally broken and causing that system to change, which you have all testified as to exactly how that's happening. So I just want to thank you all so much. And I'm going to turn it now back to Maria, who's going to close us out.
Yep. I had to find the unmute. Well, that was fascinating as always. Thank you so much for everyone that engaged in the chat. For any questions that we didn't really touch on, we do want to explore that in a resource that'll go out after this webinar. We're going to follow up with an email with the recording and the slide deck And then maybe it's going to take us a couple of days to just gather all the questions and answers and send them along to folks so that they have something physical to hold on to after this webinar. I do want to remind folks, you've seen this in our news e-alerts and newsletters, but we have an upcoming webinar, the ABA Results Educational Fund and the NCCRC are partnering on a webinar on April 24th called Addressing the Epidemic of Evictions, What Advocates Can Do on the Local, State, and National Levels. We will send along a link to that in the follow-up email. I also encourage you to just watch out for more information about a webinar we're hosting in May about a new resource that we're releasing that we partnered with the Case Made on about advancing the civil right to counsel by anchoring your case and your message in racial justice. We're also very excited to just do a little teaser about a third Right to Counsel Sprint, a boot camp series that we do with Results for America and Policy Link, and our partner this time around, also Pablo Estupiñan from SAGE will be partnering with us on that. We're very excited about that coming in the fall. Keep an eye for news alerts. If you want to sign up for alerts, head to civilrighttocounsel.org and you'll just find more information on civilrighttocounsel.org, our website. Thank you so much to everybody that's made it out. We did it on time, everyone. Thank you to all of our fantastic panelists, Aura, Thomas, Pablo. Thank you so much for joining us, and to everyone that asked questions in the chat. Really excited to have spent this time with you all. Thank you, John, for facilitating. And we'll see you later.